I'm not going to force her to go over somewhere to stay 10 days when she's barely stayed 3.
When you changed your address 5 years ago, did you notify him?
He's been over here, Your Honor. Yes.
That wasn't my question. Did you notify him? Okay. Did you enroll the child in a new school?
Because
No. Hold on.
Been in new school for the last year. She's in new school.
The questions, I just want yes or no.
Yes. He never wanted to know.
I just need some type of accountability.
All it takes is one violation. So out of all these violations, if the court finds that you violated at least one of them, you can be held in contempt. Okay. And Attorney Plummer, you can make your objection on the record once we go on the record. Okay.
Okay.
All right. We're on the record in cause number DF1500398. Counsel, will you please announce for the record?
Natalie Plummer representing the petitioner, Torian Stenser.
All right. And Ms. Pennington, you are the respondent in this matter. Is that correct?
Yes, Your Honor.
And you submitted to the court that you will be representing yourself. Is that also correct?
Yes, Your Honor.
Okay. And Attorney Plummer, you had an objection you wanted to make?
Yes, Your Honor. I object to the admission of any witnesses offered on behalf by the respondent, any evidence that she hopes to introduce today on the basis that she is to be treated as an attorney since she's representing herself pro se. She should be held to the same rules that any attorney would be, especially with regards to the court's policies and procedures, specifically that she was required to file any exhibits earlier before now, as well as any witness or exhibit list. Or any witness list. And so I object to any witnesses or any documents or evidence that she intends to introduce.
Okay. Ms. Pennington, do you understand her objection?
I don't understand it, but she's going to, depot herself through it anyway. So that's fine, Your Honor.
Okay. Well, I was going to explain it to you. And a motion for enforcement is considered a final trial. Mm-hmm. And anytime you come before a final trial, there are rules that you have to comply with, not just necessarily the court's rules, they're statutory. Based on what the state of Texas rules say about any presentation of witnesses as well as exhibits that you're going to use. So essentially, the law allows me to exclude evidence if they're not proper before the court, meaning you didn't follow the rules. So at this time, I would be granting her objection.
That's okay.
Okay. Mm-hmm. All right. So
I provided evidence last time, but no one never presented them, but it's fine.
Well, you mean when you emailed them to Destiny?
To the court, yes. And I went up there to the office as well.
Okay. So let me explain that to you.
Okay.
Because you are representing yourself, you're held to the same standard as anyone else. Mm-hmm. As an attorney as well. So when you submit evidence, you're not actually putting on that evidence to the court. You actually have to introduce it. By virtue of sending it, mm-hmm. I can't even take it into consideration unless it's presented. Okay. Does that make sense?
Yes, Your Honor.
Okay, so this is what I'm going to do. Ms. Twine, thank you for your time, but it doesn't look like we'll be needing any testimony from you today, okay? Thank you. He said you all. And this is a 30-minute hearing. You all have 15 minutes per side. Attorney Plummer.
Yes, Your Honor.
Hold on. I'm speaking out loud and typing your name at the same time. I'm setting you all's clocks. So, Ms. Pennington,
yes,
within this 15 minutes, this will include any opening statement, should you choose to make one. You don't have to make one if you don't want to. It'll also include any closing statement you would like to give to the court, as well as any direct or cross-examination. So you do have the opportunity once Mr. Stenser, once Attorney Plummer passes him, that's your opportunity to ask some questions based on his testimony. Now, Attorney Plummer has the right to object. So if your questions are not proper or legal within his testimony, right, she has the right to object. So I just want to make sure that you understand that, just like you have the right to object to any questions that she may ask of her client, just know that if it's not a legal objection, I can't entertain it.
Okay.
Okay.
Yes, Your Honor.
All right, so you all are set at 15 minutes aside. Attorney Plummer, would you like to give an opening statement?
Yes, Your Honor.
Okay, you may proceed.
On January 27th, 2015, the court entered a child support review order establishing the parent-child relationship in this matter between the Torian Spencer and Dewana Pennington regarding the female child, Skylar Pennington, born July 15th, 2014. They were granted joint conservatorship and rights and were established as far as visitation in that order. As a result of this, Ms. Pennington has chosen not to follow this order and has violated the court's order at various times. Specifically, she failed to, I should say, follow the court's order to allow my client his Wednesday weekends, first, third, and fifth weekends, his Thursday, Christmas, and November for Thanksgiving vacations for the child. She's been denying him access to the child for her birthday. She failed to provide my client, in accordance with the order, the notice of her change of address, notice of change of her employment or work number, and to date had not actually followed the court's order to provide any of this information, therefore denying my client the opportunity to exercise his rights. We are requesting at this point, we're moving forward with a contempt, and we are wanting, and that's where we are, why we're here today.
Thank you. All right. Would both sides raise their right hand? Do you swear or affirm that the testimony you'll give will be the truth and the whole truth?
I do, Your Honor.
Yes, I do.
Thank you. You may lower your hands. Ms. Pennington, at this time, if you would like to give an opening statement, you may.
Your Honor, so I put Torin, Mrs. Spencer, on child support back in, I think it was back in September of 2014. She was born in July, but I didn't do it until September because I was advised by someone that he was throwing parties, doing everything else.
Objection, Your Honor. She's giving a narrative.
Hold on one second, Ms. Pennington. Go ahead, Attorney Plummer.
Objection as to narrative. And she's giving testimony versus an opening statement.
Sustained. So, Ms. Pennington, once it's your opportunity to speak in terms of responding to the allegations against you, that's when you will.
Yes, Your Honor. I wasn't going into deep. I was just telling, starting it out. But let
me like streamline this a little bit for you. On opening statement, you're pretty much telling what the evidence is going to show or what the evidence is not going to show. So you're being accused of violating the order. So that's how you would kind of respond in an opening statement. It doesn't have to be, anything long and where you're defending yourself, right?
Okay.
You do that when it's time for examination.
Okay. So I've never denied Torin his rights. Basically, he's denied himself. I've never denied his rights. I have allowed him to get his child. I have text messages for him getting his child. I can't deny you. I went years without reaching out to him, trying to see what works best for him.
Objection, Your Honor, testimony.
That's all I can say, Your Honor. I've never denied him his rights. Never.
Okay. Thank you, Ms. Pennington. Attorney Plummer, you may call your first witness.
Thank you, Your Honor. I call my client, Torian Spencer.
Okay, Mrs. Spencer, would you please remove yourself off of mute?
Yes.
Okay, Attorney Plummer, you may proceed.
Mr. Spencer, were you part of a hearing which resulted in an order on January 27th, 2015 before the Attorney General's Court?
Yes.
And in that hearing, were you granted rights?
Yes.
And were those rights specifically addressing weekends?
Yes.
Were you granted first, third, and fifth weekend of each month?
Yes.
And were you allowed to have your first, third, and fifth weekend of each month?
No.
Okay. Let's start with the order. Let's go in order. Were you given specifically Thursdays?
Yes.
Were you given Thursdays from 6 to 8 p.m.?
Yes.
And specifically on the Thursdays that are listed in the motion for enforcement, in the interest of moving forward with this case in a manner that can be handled quickly for the court, do you believe that you were denied access on Thursdays starting in November of 2022?
Yes.
Okay, and you were denied, so I'm going to go through them very quickly. So I just wanted to make sure that we list all of them so that the court can consider them. Okay.
Yeah.
All right. Were you denied access on Thursday, November 10th, 2022?
Yes.
On Thursday, November 17th, 2022?
Yes.
On December 1st, 2022?
Yes.
December 8th, 2022?
Yes.
December 15th, 2022?
Yes.
January 5th, 2023?
Yes.
January 12th, 2023?
Yes.
January 19th, 2023?
Yes.
January 26th, 2023?
Yes.
February 2nd, 2023?
Yes.
February 9th, 2023?
Yes.
February 16th, 2023?
Yes.
February 23rd, 2023?
Yes.
March 9th, 2023?
Yes.
March 23rd, 2023?
Yes.
March 30th, 2023?
Yes.
April 6th, 2023?
Yes.
And then I'm gonna do these quickly. April 13th, April 20th, April 27th of 2023.
Yes.
May 4th, May 11th, May 18th, and May 25th of 2023.
Yes.
August 10th, 17th, 24th, and 31st of 2023.
Yes.
September 7th, 14th, 21st, 28th of 2023.
Yes.
October 5th, 12th, 19th, and 26th of 2023.
Yes.
November 2nd, 9th, and 16th, and 30th of 2023.
Yes.
December 7th, 2023.
Yes.
When you attempted to exercise your visitations with Ms. Pennington, were you given an excuse?
Yes.
Were they excuses that prevented you from being able to see your child between the hours of 6 and 8 p.m. on Thursdays?
Yes.
Were there instances where you attempted to reach her by phone and were not able to do so?
Yes.
You were denied your visitations on Thursdays. Is that your understanding?
Yes.
Let's deal with your weekend violations. Were you denied access on November 18th, the third Friday of the month of 2022?
Yes.
Were you denied access for your child for the first Friday of the month of December on December 2nd, 2022?
Yes.
Were you denied access to your child at 6 p.m. on Friday, December 16th, of 2022, which was the third Friday of that month?
Yes.
Were you denied access to your child on the first Friday of the month of January, which was January 6th, 2023?
Yes.
Were you denied access to your child on the third Friday of January on January 20th, 2023?
Yes.
Were you denied access to your child on Friday, February the 3rd, 2023?
Yes.
Were you denied access to your child on February the 17th, 2023?
Yes.
Were you denied access to your child on the first Friday of the month on Friday, March 3rd, 2023?
Yes.
Were you denied access to your child on Friday, March 31st, 2023, which was the fifth Friday?
Yes.
Were you denied access to your child on the first Friday on April 7th, 2023?
Yes.
Were you denied access to your child on Friday, April 21st, 2023, which is the third Friday of the month?
Yes.
Were you denied access to your child on March the 5th, 2023, which was the first Friday?
Yes.
Were you denied access to your child on Friday, May 19th, which was the third Friday of the month?
Yes.
Were you denied access to your child on Friday, June 2nd, 2023, which was the first Friday of the month?
Yes.
Were you denied access to your child on June 30th, 2023, which was the first Friday of the month?
Yes.
Were you denied access to your child on Friday, July 7th, which was the first Friday of the month of 2023?
Yes.
Were you denied access to your child on the first Friday of the month, Friday, August the 4th, 2023?
Yes.
Were you denied access to your child on the third Friday of the month, August 18th, 2023?
Yes.
Were you denied access to your child on Friday, September the 1st, 2023, which was the first Friday?
Yes.
Were you denied access to your child on the third Friday, on Friday, September the 15th, 2023?
Yes.
Were you denied access to your child on the fifth Friday, being September 29th, 2023?
Yes.
Were you denied your child on the fifth Friday of the month at 6 p.m. on October 20th, 2023?
Yes.
Were you denied your child on the first Friday, on Friday, December the 1st, 2023?
Yes.
And were you denied your child for your Christmas vacation period of this year, which from 6 p.m. for possession of your child?
Yes.
Of 2022, I'm sorry.
Yes.
All right. Were you denied Father's Day visitation for this year on June 16th?
Yes.
All right. Were you denied your summer possession, which you're entitled to by law, in the month of July of 2023?
Yes.
Were you allowed to see your child on her birthday, July 15th, 2023?
No, not for the full time. No.
Were you able to see the child for the entire period from 6 p.m. to 8 p.m.?
No. I was
And
able to give a gift and leave.
Were you allowed to exercise your court-ordered visitation at the residence of Duana Pennington?
No.
Okay. Let me move forward. Did she violate the possession and access order by failing to provide you with the name of your child's new school and address?
Yes.
And did that deny you your right to be able to begin your period of access at the time the child's school is regularly dismissed?
Yes.
Now, she violated the court order and other statutory violations as well. Is that correct?
Yes.
Did she fail to notify you of her change of employer on or before the 60th day before the expected change, or that she was required to give the information?
Yes, she failed to do so.
Did she also fail to provide that information to you at any point to date?
Yes, she failed to do so.
In fact, in a hearing before this court in July, did she not refuse to provide her address information, even when the court made it clear that she was required to give it to me?
Yes.
Did she provide you with a notice of her new work phone number on or before the 60th day of the expected change of that information?
No, she did not.
As to date, has she given you her work phone number?
No.
Okay. Did she provide, to your knowledge, did she provide any of this information to the court or the court registry of her change of address, her change of employer, or her change of work phone number?
No, she has not provided it.
Now, you have a right to be notified of all of these things. Is that correct?
Yes.
And in the court order that was entered on July the 15th, July 27th, 2015, she specifically was required to make sure that you were given this information if she changed the school of the child that was enrolled for the 2023-24 school year. Is that right?
Yes.
And provide you with name and address. She didn't give you any of that information, did she?
No.
Did she even attempt to confer with you with regards to changing the school?
No.
So you were denied that right as well.
Yes.
Did she give you the attempt to confer with you before she made a decision concerning the health, educational welfare of your child?
No.
Did she fail to confer or attempt to confer with you prior to doing any of these things?
Yeah, she failed to do so.
Did she designate you as a person to be notified in the case of an emergency on the child's school records?
No.
At this point, there's a lot of violations that we've discussed. Did she give any good reason as to why she denied the court's order?
No good reason, not according to the law.
Did she actually block your phone number for a period?
Yes.
And did she deny you access to your child for these reasons?
Yes. She actually even blocked me on the tablet that I bought my daughter so I can be able to communicate with her.
You had you had Thanksgiving this year, is that correct?
Yes.
And you were denied your child during that period, is that correct?
Yes.
Did she actually let you have your daughter and then later refuse to return your daughter to you?
That is correct.
Are you seeking to put your child's mother in jail today?
Honestly, no.
Would you be satisfied with the court placing her on probation so that she is required to report to a community supervision officer and required to follow the court order from this point forward or face jail time?
Yes. I just need some type of accountability.
Have you incurred attorney fees with regards to all of this to pursue this entire matter?
Yes.
And are you requesting that, have you incurred attorney fees in the amount of at least $11,246.12 in order to, with all the various communications of violations and everything since this matter was filed in the summer?
Yes.
And you had to incur costs for a process server, is that correct?
Yes.
And you believe that the court should reimburse you for all of your costs and expenses associated with this matter, is that true?
Yes.
Do you believe that this is in the best interest of your daughter?
Yes.
Do you want to spend time with your child?
Most definitely. Uninterrupted time.
I'll pass the witness at this time, Your Honor.
Okay, and counsel, you just ran out of time. Ms. Pennington, do you have any questions for Mr. Stencer based on his testimony?
Oh, yes, Your Honor.
You may proceed.
Mr. Stencer, before November 2022, have you ever been denied access to your daughter?
Yes.
Before November the 22nd, November the 22nd, 2022, the reason why you didn't have access of your daughter, was it because you tried to put a fake assault case on me?
It wasn't a fake assault case. You actually came to my house.
I asked you.
I'm answering the question.
Okay.
You tried to force yourself into my home, and you actually took my daughter, which was during the time period that I was supposed to have her, according to the order.
Okay,
and you
Mr. Stencer.
assaulted me in the process, as well as went around to my backyard, tried to force yourself into my home, and this was in front of our children as well as my stepchildren.
Your stepchildren okay, never mind. Okay, before then, Mr. Stencer, since you said that, on November the 5th, when that took place, that was on a Saturday, correct?
Yes.
On November the 4th, which was a Friday, did you come and get possession of your child?
No, my mother did.
No, correct. So before November the 4th, 2022, have your child, no, I'll take that back. Hold on, let me go to before November the 20th, so November the 4th, 2022, why didn't you come and get your child per your court orders?
I would try. most of the time I did not try to deal directly with you because of your aggressive behavior and because you're very confrontational. I even tried to do a communication setup to where it was you, myself, as well as my mother on a text thread, because with you and I being by ourselves, it just wasn't working. Every time I said or did anything, then I'm wrong. And so I felt like I needed some type of other accountability piece to be able to at least try to have some order for me to be able to get to my daughter.
Mr. This is just beyond me. Mr. Spencer,
Objection, Your Honor.
before.
Hold on 1 second, Ms. Pennington. Counsel, what's your objection?
My objection is to the extra antics and attitude being thrown out by Ms. Pennington with her response to my client's testimony.
Sustain as to sidebar. Ms. Pennington, after you ask your questions, you can't then turn around and make comments afterward. Okay.
Okay. Mr. Spencer, before November 2022, last year,
Objection, Your Honor, irrelevant as to the time frame in
you
this.
won't even let me ask the question, ma'am. I'm trying to ask the question.
Hold on. Finish answering your question, and then Attorney Plummer, you make the objection. Go ahead, Ms. Pennington.
So as of November 2022, how many times did your daughter spend the night at your house before November 2022?
Actually,
Objection, Your Honor, irrelevant as to my client has a right to the possession, whether he exercises it or not. He attempted to, this order is with regards to information, the violation that took place after November 5th, 2022. Anything before that date is irrelevant.
Sustain. So the dates that we're working with, Ms. Pennington, according to the motion, okay, I don't see a date in here for November 5th. The dates that I see start November the 10th of 2022, and they go all the way through, looks like August of 2023. So those are the dates that we're working with.
Yes, okay. So nothing before matters that he didn't do what he's supposed to do before. So just now because he's trying to, okay.
Objection, sidebar.
No, I think she was asking, overall, I think she was asking a question. So
yes, nothing before November the 10th of 22 matters.
and I actually want to
hold on, Mr. Spencer, hold on. I think she's asking me the question.
Yes.
It matters in the sense of if you're trying to show a history, but the actual dates that they're talking about are November the 10th, starts at November 10th, 2022. So I can't tell you how to put on your case. I can just tell you, if you want to stay on track and avoid the objections that she's making, work with each one of those dates that he listed in his motion. Do you have the dates?
So November starting November the 10th until August 23rd. The reason why you didn't see your child is because, well, I'm gonna take that back. August 23rd, I think that's what you said. After August 23rd, which was the end of the fake assault case you tried to put on me, you started
Your Honor.
seeing your child, correct?
Objection, Your Honor, objection as to assuming evidence. There is nothing has been shown that there was a fake assault charge.
I got the dismiss, so I guess I need to find the documents for the dismiss.
If you would just rephrase it instead of saying a fake charge, you can say it was dismissed. So
from November the 10th, 2022 until August 2023, you weren't able to see your child because of the alleged assault case, correct?
I was not able to see her because you denied my access. And this actually started before this. But that was, I guess, the
objection, Your Honor. Objection. We stated the dates, right? We stated November the 10th until August 23rd, correct? So nothing else before that basically matters, right?
Well, I didn't say it didn't matter. It's the way that you have to use it. If you're trying to use it to show a history of him not showing up, that's one thing. Not necessarily specific dates, but just, in the past not showing up. But what I'm saying is in terms of the violations, The only violations that they have on here start November 10th, 2022. And the last one, I said August the 23rd. I meant August the 10th of 2023. Those are the actual dates that you should be asking him questions about. That's why I asked you if you had a copy of the motion, you can go date by date.
Okay. No, I don't have a copy of the motions. But
hold on one second. Attorney Plummer, would you mind sharing your screen and pulling up the motion so she can actually work with the dates? And then you can ask him specifically. You can look at the violation and ask him specifically about each date. Okay.
Okay.
That'll help you with defending your case, and it'll keep you from running out of time too. If you have the motion in front of you.
Okay. So,
excuse me, Your Honor, I would like to point out that not only was she provided a copy by the court coordinator when she decided to, when she participated in the selection of the first hearing that was set, she also has been personally served with this motion, as well as the order to be here today. So she should have access, but I have no problem sharing my screen. Hold on just a moment while I try to figure that out.
The last court, but I think I have it over here.
Okay, can you see it?
Yes, ma'am. Thank you. Could you zoom in a little bit?
Hold on, I'm about to see if I can widen the screen. There we go.
Miss Pennington, she pulled it up on the screen for you.
Okay, I went and got it too.
Okay, all right. So if you start on page 5, I think.
Yes, page 5 deals with the Thursday violations. Page 4 starts with some of the rights that were violated in the court order.
Yes, if you wanted to start at the bottom of page 4, Ms. Pennington, and ask him questions based on each one of those violations. That will probably be more helpful. Attorney Plummer, thank you for sharing your screen. You can stop sharing it. She has the paper in front of her now.
Thank you.
I think I do. It's a lot, Your Honor. She could have kept it up there, but it's fine. Before the November the 10th. Well, I'm sorry, we can't even go before November the 10th, huh? Yeah. Again, I've never denied you.
Hold on. He's on the witness stand, so you have to ask him questions unless you're done asking him questions. Did you get the motion so you can see the allegations?
You know, I work 2 jobs. Let me tell you, this is beyond me. Too much of my time. Just got off work this morning. Again, before November the 10th, have I ever denied you possession of your child?
Yes.
Okay.
When you have plans for her, even if it's my time, then you think that your plans supersede my time, which is according to the order.
So I asked, for November, for Thanksgiving, did you not receive your daughter on that Friday?
Objection, Your Honor. As to vagueness, she needs to specify the year she's referring to.
2020, what's this, 3? Did you receive your daughter?
Yes.
Did your daughter?
And I actually
hold on. Y'all can't speak at the same time. My court reporter can't get what both of you are saying. I believe the question was, and I don't think I even addressed the objection. It was sustained, and Ms. Pennington clarified her question for 2023. I didn't catch your question at all, Ms. Pennington, because the two of you started speaking at the same time. So ask your question again.
I asked him before, did he receive his daughter for November the 17th for Thanksgiving on that Friday?
And my answer to that is the only reason I was able to get my daughter is because I've been communicating with her directly and through her aunt, who's actually trying to do what she's supposed to be doing, which is allowing me to access my daughter. It wasn't through you.
How do you think that how you get her? Oh, okay. So, Your Honor, your daughter reached out to you, correct, Torin?
Yeah, I actually reached out to her and she reaches out to me as well.
Correct, because you send, do you not send me an email regarding your weekend possessions now?
Yes.
You just started sending me emails, correct?
Mhm.
So when you send me emails, I let your daughter know to reach out to you so you all can talk. Correct. So your daughter,
Objection as to
So your daughter-
speculation. Objection as to speculation, Your Honor. He can't know what she did or did not do.
your daughter not
If
reach you, contact you on your tablet.
Hold on, Ms. Pennington, hold on. She's giving the objection and she has to state it for record keeping purposes. Counsel, I see objection to speculation sustained. Ms. Pennington, ask him questions that will be within his knowledge, not necessarily where you're asking him to speculate. Because if he doesn't necessarily know, you're going to always get that objection from his attorney.
Okay. Did your daughter let you know that she wanted to go and spend time with her friends during Thanksgiving break?
Yes.
When you contacted your daughter on Thanksgiving to ask your daughter about the time that you wanted to come get her, did your daughter not tell you that she didn't want to go?
After you took
Yeah.
her in your possession and she was actually supposed to be at her aunt's house, yes, she did make that statement while she was in your possession, which she wasn't supposed to be. And I actually reached out to you that same day because I know that as a kid, she shouldn't have that decision, because especially with us having a court order, and you still denied my access.
Yes, I did. Well, I did deny. I'm say this because I don't want my child to be uncomfortable.
She's never been uncomfortable.
She let me know right hand to
Objection, Your Honor, hearsay.
again. I don't.
Ms. Pennington, ask him questions, not argument. When it's your turn to speak, then you can speak freely, but ask him questions, okay?
Okay. Okay. So your daughter reached out to you and told you that she didn't want to come over there, correct, via her tablet. She didn't want to come back.
Objection as to time frame.
November.
Sustain, which day are you talking about, Ms. Pennington?
Let me pull up whenever Thanksgiving was the 24th, 23rd this year, 2023.
Yes.
So your daughter, correct?
Under your possession, yes.
To allow this app to make changes. I'm sorry, hold on, Your Honor. Something popped up on my thing. It took away. Okay. Okay. Something popped up on my computer and took it away. That's, Your Honor, I honestly don't have no more words for this man.
Okay. All right. So Attorney Plummer, you're out of time. Ms. Pennington, this is your opportunity to tell the court whatever you want the court to know. Just know that anything you say can be used against you, okay? And although Attorney Plummer is out of time and can't ask you any questions, I can ask you questions based on your testimony, okay?
Okay, and this has to be regarding November this last year to now, right?
Yes, ma'am. So all of these allegations, like I said, you are defending yourself against each one of them. I just want to be clear, though, on an enforcement, he doesn't have to prove that you violated each one of them. All it takes is one to pop you, okay? All it takes is one violation. So out of all these violations, if the court finds that you violated at least one of them, you can be held in contempt, okay? So I just want to make sure that you understand that part. And the dates that we're working with are November 10th, 2022 through October the 10th of 2023. Those are Thursdays as well as first, third, and fifth weekends. He's also alleging violations of you not providing the school information when you allegedly enrolled the child in a new school, concerning your address, not turning over information about your work address as well as your home address. So all of those allegations is what he is alleging. So in your testimony, you're free to defend yourself on each one of those allegations.
Okay.
Okay, go ahead.
So again, I've never denied you any type of rights to Skylar.
Objection, Your Honor, to speaking to my client directly.
How do I speak? Do I just talk and
You
say?
speak to me. You're talking to me.
Okay, Your Honor, I've never denied touring rights, and that's right. I have no reason to lie. That's right hand to God. Every time Scholar's been in school, honestly, he has been on the school documents, but Torin has not reached out to see about homework. Torin has not reached out to see about her STAR test. The last year was the first time Scholar has ever spent the night at Mr. Stencer's home. Mr. Stencer has a home that he's never made a home for Skylar. She's never had any type
Objection,
of
Your Honor, testimony.
Well, this is her statement. She can give testimony.
She's never had a room at Mr. Stencer's home.
Objection, Your
Spencer
Honor,
has-
irrelevant.
Mr. Spencer-
How would she know what if she's never been
Mr.
inside his
Spencer
home?
has, because my daughter lets me know. Skylar, me and Skylar.
And you can't tell me what the child said. That's hearsay.
Okay,
Just speak to, as I said, that's why I said, if you have the motion in front of you, it's easier if you have it, so you can stick to the violations.
Skylar went over during Thanksgiving break. Skylar is used to going with her friends and family on Thanksgiving breaks. Skylar wanted to make cakes and pies with her friends. She went over there. Skylar came back. She knew she had to go over her dad's house. I let her know, you got to go back over your dad's house. She came to me Thanksgiving and said, Mama.
Objection, hearsay.
Sustain. You can't tell me what the child said.
Okay, well, she didn't want to go back. So I advised her, reach out to your dad and you let your dad know. At the end of the day, Your Honor, my child has never, I'm going to say it, Your Honor, I'm not going to force her to go over somewhere to stay 10 days when she's barely stayed 3. And that's throughout, since she's been 9. Skylar has never spent the night at his house but one time last year. Skylar doesn't feel like his home is her
Objection,
home.
Your Honor, speculation.
Okay, well, my child has her own room here. She has her own toys here. She doesn't have to share rooms, or she doesn't have to sleep on futons.
Objection, Your Honor, speculation and
There's no
irrelevant.
speculation, Your Honor. My baby FaceTime me.
Argumentative.
My daughter has FaceTime me, and I have seen the conditions. And that's the God honest truth. My daughter is loved by her granny, by his mom. Absolutely. Anywhere she has had a residence, she has made Skylar have a home, have a room. All of Skylar toys is at his mom's house. Everything that Skylar loves her granny. That's off top.
Objection, Your Honor. This is getting off point.
Just honestly let you know, Your Honor. Again, right hand to God, I've never denied. I've always been there. I have reached out to Mr. Stencer and asked him about the relationship with his daughter. How can we a relationship? He has denied me. He has told me to go to
you just ran out of time.
Okay, that's fine.
Ran out of time. Okay, I have a question. A couple of questions for you, Ms. Pennington. Did you enroll the child in a new school?
No, hold on. New school for the last year.
Hold on.
The new school.
The questions, I just want yes or no.
Yes.
Did you enroll the child in a new school?
Yes.
Did you let him know that you enrolled the child in a new school?
No, I didn't let him know last year.
Okay.
He never wanted to know.
Okay. So, home address, does he know where you live?
Yes, he's always known where I live for over the 5 years. Nothing has changed.
Objection.
What's your objection, counsel?
Objection as to the question was, did she notify him of the address? And her answer is, he knows. That's not the same thing.
Well, I actually didn't ask the question right. I need to rephrase it because I asked, does she know where he lived? Let me ask the better question. Did you notify him that you were changing your address?
My address been the same, Your Honor.
No, it's not.
When you changed your address 5 years ago, did you notify him?
He's been over here, Your Honor. Yes.
That wasn't my question. Did you notify him? Okay.
He had to come get her. He had to come see her. So he was notified.
Yeah, I only got the information through my mother.
Because you advised me to go through your mother. But
Objection.
Hold on. You all do not have to talk to each other right now.
I got a sticky note over his face, Your Honor. I don't even want to see that man.
Oh, okay. Miss Pennington, that's not necessary.
Just saying.
Did you recently change your job?
It's been a year.
Okay, did you notify the court of your change of address at your job?
No.
All right. I'm just going through their motion, asking you. I didn't hear testimony on this.
Yes, Your Honor, he gave testimony on that. Do you have a copy of the order?
Oh, I'm saying from her. I heard his testimony. I didn't get her testimony. Okay. Someone just came into the courtroom. You all give me a few minutes, okay? Hold on.
Okay, Your Honor.
All right, we're back on the record. Okay, we're back on the record. So the court ordered you all to go into a breakout room to speak, and it's the court's understanding that it just didn't work. You all couldn't come to any sort of resolution.
Just like I told him,
Well, you don't have to tell me those are settlement negotiations.
well, I can meet him at QT. Well, my auntie can meet him at QT. She asked about that. I said, there's no problem. She wanted to know about any additional days that he didn't get her or whatever, just like I advised. I have no problem with that. I will let Skylar know that. But, and my daughter's 9. She's not 8. She's 9, gonna be 10. And that's it. And I agreed to no. I'm not about to pay for something that no, Your Honor.
Okay, and I respect that. I at least, appreciate you all attempting to do it, right? That was a big step. The reason why, well, let me say this before I give my ruling. A child cannot say who they want to go with. They can never say that. Skylar cannot say when she's at daddy's house, I don't want to go back to my mama's house, and dad not turn her over. It doesn't work like that. Same thing with you. If she says she doesn't want to go with dad, you still have to turn her over to dad, because the court order is between the two of you, and you still have to follow it. There is a thing called passive denial. So if the child say they don't want to go, you're not actively telling the child they don't have to go or they can't go, but you are passively denying possession and access. And that could bring you right back here again, Ms. Pennington. And I know you don't want to be here. So,
For my baby, Judge, I will. For my baby, I will.
Okay.
And that's not honest truth.
Okay, so I just want both of you to understand that you have to follow the court order, what it says. Now, if you all agree to exchange at QT, that is your agreement. However, this court order does not say that. So if absent an agreement, you all default to the order. Something else I wanted to make sure is clear. You all can send any competent adult to exchange your kids. It says it in your court order. You can send an aunt, uncle, boyfriend, best friend, whoever is considered a competent adult. They can do the exchanges, so you all do not have to deal with each other. I just want to make sure you both understood that you have the right to do that. All right. Okay. Now that's my admonishment for the in terms of following the order. Now on the motion for enforcement, it is a very technical motion, and according to section 157.002 of the Family Code, I'm not able to hold her in contempt. The violations are not specific enough contained in the motion to actually hold her in contempt. And because no testimony was put on about attorney's fees and the expenses, I can't even award that.
Your Honor, we weren't given, I didn't have enough time to do that, to go through all of her 80-something violations and get to the attorney fees, but my client did specifically state that he did incur $11,246.12 for process service and in payment of attorney fees. So that part would at least got in. And in the order,
that made it in, but you have to put on the testimony for the attorney's fees. Like, you have to call yourself as a witness and actually put on testimony for that. I just can't award it because it made it in the record. Like, I actually have to hear the testimony from you to prove up those fees. And in regards to the actual violations, they have to be specific: date, time, manner. My review of the record was, you asked him, did she deny? And he said yes. That's not how you prove up an allegation on a motion for enforcement. You actually have to go through each one well, you don't even have to go through all of them if you choose not to, but you have to, it's twofold on an enforcement. You can't only show that she violated, you also have to show that your client was in compliance with it. They're very technical motions, and
well, Your Honor, I tried to, but we ran out. You cut off my time. I didn't get a chance to go for it. He did explain that he was denied all of them because she gave excuses for why she would not allow the visitations. And other times she just didn't answer his calls. He stated that on the record. There was testimony with regards to that. And if the court would allow, I'd be more than happy to go ahead and prove up my attorney fees, because this was ongoing violations even after she was made aware of the motion and provided a copy of it via email, as well as later served personally.
And counsel, I understand what you're saying. However, the way he has to be asked a little bit more on a motion for enforcement in order for me to do anything. Statutorily, the chapter 157 does not allow me to award any makeup time, holder in contempt, or anything based on the questions that were asked. And the motion itself is defective. It has to be very specific. Otherwise, I can't do anything pursuant to what the law says. That's not me. That's what the law actually says.
Your Honor, I'm confused as to why it's not correct, because it gives the actual date. It gives the it says the first, third, or fifth Friday. It specifies Thursdays. It says the child was not made available at all on those dates. It's provided in the motion. It gives all of that and precedes it by quoting the actual order that provides for the violations. I followed everything that's in there. Where is it that you state that it is not, that it is somehow defective? Because I provided everything in the order specific as to the wording.
Well,
and this is,
go ahead.
So I'm confused as to how is it defective, because it provides everything that I was required to provide.
Okay, one, you failed to comply by surrendering the child. You actually, in your violation, you have to show what took place. Like, did he send her? So it's twofold. Like I said, you have to show that she actually violated, but you also have to show what he did to be in compliance with it. The court didn't hear any testimony or anything to say that he was there at 6 o'clock. It doesn't state the manner, the location where you're supposed to trade. Exchange, it says Deanna Pennington failed to comply by surrendering the child to Torian Spencer on Thursday, January 26, 2023. The child was not made available. The child was never identified. There's no name of the child in the motion, which that's fatal, as well as it didn't state the location. Like, what does the order say they're supposed to exchange? That has to be in the actual violation in order to comply with the rules in ex parte Slavin. Okay,
because it specifically names the child of the suit.
Right, but you have to do it in every violation. Every violation. According to ex parte Slavin, you actually have to track the language of the order. So how you wrote out the language there, you'd have had to do the exact same thing on each one of the violations in order to hold her in contempt. Otherwise, the law doesn't allow me to hold her in contempt. And if it's defective, I mean, I can't do anything with that.
But that's how the actual 2015 order, I did it verbatim, word for word. Is they didn't specify child anywhere in that there. So I repeated it just as it was in the order.
I understand what you're saying. However, legally, you have to actually identify. That's what the language says. But even tracking the language, you put her name and his name. There's no child's name and there's no location. The child's name is not as big of an issue as the location. That has to be mentioned on each one of the violations where they're supposed to exchange. It specifically says in 157.002, part A under C, a motion for enforcement, the terms and conditions of conservatorship or possession and access must include the date, the place, and if applicable, the time of each occasion of the respondent's failure to comply with the order. So on each one of those violations, you would have had to say what the place was according to the order. So if the order is dad's residence, it had to be outlined as dad residence. If it's mom's residence, it has to be outlined in terms of mom's residence, or the public place, whatever location it is, it has to be mentioned in there. Otherwise, it's defective.
Even if she doesn't provide any information, he didn't know where the child was.
Even if your
got you.
motion, yes, he has to show, it's a very technical motion, counsel. So that's the issue.
Okay, I'd like to request a motion for leave to amend, or it cannot, because shouldn't I be allowed to amend on the record right now, since we're still in the hearing?
Well, no, and that's another thing. You have already had an entire hearing, and I made a ruling. So there wouldn't be an amendment. You would have to file a new motion.
Okay.
And that's the reason why I wanted you all to go and have a conversation to see if there was anything that could be worked out, because the court couldn't give any relief that you all were seeking today pursuant to the law.
Okay. Well,
Okay.
we have information available now, and so we'll just do that.
Okay. All right. Now, Ms. Pennington, Mr. Stencer, before you all leave, do you have any questions about what your obligations are under this court order?
So we're just sticking to the same court order that was already in place.
The same order. Until an order is modified or changed, it has to be followed verbatim.
So it's no accountability on her end.
Well, I didn't say that. I admonished her. So that's the most I can do today.
She's not gonna do right until there's some kind of accountability.
You don't do right before then. You
Okay,
ain't
hold
doing
on. Y'all are not gonna argue back and forth.
it. I'm not, because it's
I said what each of you need to do in compliance with the court order. That does not mean, Ms. Pennington, he can't come back and bring another motion. That does not mean, Ms. Pennington, if for any reason he violating the order, you can't bring a motion on him. But in terms of, like I said, the statute, I can't do anything with that.
I'll make sure my ducks is in a row. If there's a next time, I'll make sure.
Okay, so you all just follow the court order as it's written. You won't have any problems. If you can't follow it as written and you agree to do something else, your court order is flexible enough where it allows you to do that. But I just want to make sure it's clear that even if you all are following an agreement for a year and one of you decides you don't want to do the agreement anymore, the court order is still in place. You have to follow it at all times. It's the court order that is existing right now until modified.
So, Your Honor, for clarification purposes, you're not able to move forward on this at this particular time on the contempt, but we can refile it with the corrections.
Well, I can't tell you what to file or anything like that.
That's not what I'm asking. I'm just making sure that if there is an opportunity to refile with the corrections to move forward.
You can refile as many times as you need to. And Ms. Pennington, that's your right too. You all can file whatever you want to file to get before the court at any time.
Thank you, Your Honor.
You're welcome. Thank you all. You all are
Torian, call me.
Thank you. Have a great day.
Thank you, you too.
Thank you.
Torian, I'm gonna call you.